SJC-13659, Commonwealth versus Denny, Gannett.
Okay, Attorney Hennessy.
Good morning, Chief Justice Budd and Associate Justices, and may it please the Court. Kevin Hennessy, appearing on behalf of the Commonwealth. I'm joined at council table by my colleague, ADA Marina Moriarty. The Commonwealth is requesting that this Court reverse the trial judge's allowance of a motion in limine to suppress the results of a serum conversion of existing serum ethanol records reflected in the defendant's medical records that were obtained without the involvement of law enforcement. This case centers on a question of statutory interpretation regarding the consent provision in the Operating Under the Influence Statute, General Law, Chapter 90, Section 24(1)(e), that has implications for the admissibility of serum conversion results in a number of operating under the influence prosecutions across the Commonwealth. The plain language of the statute that the legislature chose, the tenets of statutory interpretation endorsed by this Court, as well as this Court's construction of the statute in Moreau and Bohegan, lead to the conclusion that the application of a mathematical serum conversion factor to existing serum ethanol results that are reflected in medical records, a serum ethanol result that was obtained without the involvement of law enforcement, and after a blood draw that the defendant consented to, that in those circumstances, the mathematical conversion of the serum result does not constitute a chemical test or analysis of the defendant's blood, as would be required for the serum conversion factor to be excluded under the statute.
So, counsel, can you just explain to me what happens here? You have the test results from the medical record, and those are inputs to some sort of algorithm that spits out, what, the blood alcohol content, or?
Essentially what happened in this case was, following his arrest for operating under the influence to offense, the defendant was transported to Beverly Hospital.
No, I'm asking more about the algorithm. I don't need to know the details, but is it that you take the medical record results and you input them into some equation, and that spits out something related to the blood alcohol content of the defendant's blood?
When the hospital draws the defendant's blood, it's in a serum ethanol result. It's in a serum ethanol form. The hospital essentially separates the solid portions of the blood, proteins and such, from the liquid portion of the blood to get a serum ethanol result, which is always going to be higher than the whole blood alcohol content level, because serum, the water has an affinity for ethanol. And what the Commonwealth did in this case was get that serum ethanol result in the medical records, send it to the State Police Crime Lab. A forensic scientist at the State Police Crime Lab, using a range of scientifically accepted conversion factors, simply did a couple of quick division problems and converted the 292 milligrams per deciliter serum ethanol result into a whole blood alcohol content level, with a range from anywhere from, on the low end, from a 0.24 BAC to on the high end, a 0.26 BAC. So the forensic scientist at the State Police Crime Lab, in this case, that...
Is it like a lookup table?
It's essentially dividing
Okay.
the 0.092, the 292 milligram per deciliter result by 1,000, and then multiplying that result by the conversion factors, which the conversion factors used by the State Police Crime Lab at the time was 1.12, 1.14, and 1.18, and that the second number is divided by those conversion factors to get the whole blood alcohol content level. So
why isn't that analysis? Why isn't that definitionally analysis?
Because, Your Honor, the statute has to be read it as its whole, and the statute says explicitly chemical test or analysis of the defendant's blood.
Yeah.
So your position is that chemical modifies analysis as well as test?
Yes, Your Honor, and I would suggest that this is supported by this court's interpretation of the statute in footnote 4 to, footnote 5, I apologize, in the Moreau decision. This court makes reference to the fact that chemical test or analysis refers to later references in the statute when it's just referenced as a test or analysis. But also, Your Honor, it's of the defendant's blood. So that connotes that what the legislature was trying to get at here was when law enforcement are actually testing or analyzing, doing something to the blood sample itself. And what happened...
Although, you know, when you do math on somebody's blood serum, whatever you call that vial, it's an analysis of the blood. I mean, I think your stronger argument is whether or not it's a chemical analysis of the blood. It certainly is a mathematical analysis of the blood. There's some algorithm, as you were eloquently describing it, of what came into the vial and the results from that, division, multiplication, and then you spit out some relevant element for the Commonwealth, right? So there's definitely a mathematical analysis of the blood. It's not directly of the blood, but it's of the blood.
And if the legislature hadn't also included the word chemical, then I agree with the court that the Commonwealth would be in a much weaker position here. But what the forensic scientists at the lab did is in many ways comparable to applying a conversion factor to inches and converting it to centimeters, because the forensic scientist or somebody making that conversion, they're not going to go out and remeasure the distance. They're simply going to apply the conversion factor to that existing result and convert it to inches or centimeters or from kilograms to pounds. And that's essentially what the forensic scientists at the State Police Crime Lab did in this case. The existing serum result that's obtained without the involvement of law enforcement and is reflected in the defendant's medical records is accepted as true, and then the conversion factors are applied to that existing result.
Excuse me, counsel. Beyond the words, the question whether chemical modifies both tests and analysis, and beyond the meaning of the word analysis, do you have any arguments about the purposes of the legislature here as reflected in the text of the statute and how your reading is or is not more consistent with those purposes?
Your Honor, I would suggest that as this court has commented on in the Moreau and Bohegian decisions, it appears just from the text of the legislature that lawmakers were grappling with a variety of concerns when enacting these provisions, including public safety concerns, but also bodily autonomy concerns. And I would suggest that construing the statute in the way suggested by the Commonwealth would reflect a reasonable compromise of these competing goals, because in this case, the medical records are going to exist whether the police are involved or not. And it would have been sensible for lawmakers to conclude to flatly prohibit non-consensual blood draws, but also to prohibit non-consensual tests or analyses of blood when it's conducted by or at the direction of law enforcement. But in this case, where the medical records are going to exist regardless of what the police do, that in such circumstances, highly reliable blood test evidence that's going to be crucial to the trier of fact in a trial should be brought to the attention of a jury, where the medical records are going to exist regardless. And what the Commonwealth is doing is just accessing those records and having a expert witness from the State Police Crime Lab and forensic scientist convert those existing test results into a whole blood alcohol content level so it can be admitted at trial. So in many ways, Your Honor, what the forensic scientist does in this case is akin to a medical doctor testifying as an expert witness at trial and explaining complicated medical terms to a jury. And that doctor doesn't necessarily have to have been the doctor who treated the patient, but the case law permits the doctor to explain those complicated terms to a jury. But the crucial point is that the forensic scientist from the State Police Crime Lab is not chemically analyzing the defendant's blood. The chemical analysis of the defendant's blood is done at the hospital. So consistent with the language that the legislature chose to place in the statute, it's the Commonwealth's position that this application of a mathematical serum conversion factor to the existing serum ethanol result simply does not fall within the ambit of the statute. I'd also just like to point out that since at least Commonwealth v. Riley, an appeals court case in 1986, there have been multiple decisions in which serum conversion test results have been discussed. And although this court hasn't squarely addressed the argument made by counsel under the consent provision to exclude the serum results, it certainly appears in looking at Riley, Russo, Doobie, which was a case from this court, that type of evidence was being admitted. And as this court observed in Bohegian, since 1994, 24.1e has been, and 24.1f, the implied consent provision, have been amended 7 times. And over the course of all those amendments, the legislature never substantially changed the consent provision in 24.1e, while there are these decisions from the appeals court and the Doobie decision that certainly seem to contemplate that this type of evidence is admissible, a serum conversion of existing ethanol results in medical records. And that implies that lawmakers were content with this type of evidence being brought before a jury in operating under the influence prosecutions, Your Honors. If there are no more questions, I'd rest on my brief, and I thank you very much.
I have a question about a procedural question.
Yes, Your Honor.
As I understand this is basically an pretrial ruling on admissibility of evidence, correct?
Correct, Your Honor.
What gives the Commonwealth the right to interlocutory review of such a ruling under 211.3?
Your Honor, I would suggest that
Do you have
under
any authority?
Yes, Your Honor, I would stress to the court that in allowing the 211.3 petition, I suspect that Justice Georges was recognizing that this is crucial evidence that is very important evidence for the Commonwealth in operating under the influence third prosecution. And were a 211.3 not to be permitted, then it essentially, in many ways, Your Honor, it's comparable to the allowance of a motion to suppress that will significantly hamper the Commonwealth's case that could.
But that goes under a specific rule. It doesn't, that's under Rule 15, that's not under 211.3. I'm just trying to figure out if there's authority for the notion that the Commonwealth gets to use 211.3 to seek relief from an adverse evidentiary ruling interlocutorily.
Your Honor, I would submit that the Commonwealth wouldn't have, where it was a motion to eliminate at the trial stage, the Commonwealth wouldn't have many other options at that point, other than seeking the extraordinary relief of this court from the trial court's decision, and the Commonwealth would have been forced to go to trial without this crucial evidence and operating under the influence prosecution. And at this point, Your Honor, where the matter has been fully briefed by both parties, and this is an issue that involves statutory interpretation, which this court reviews de novo, and it has implications for a number of other OUI cases across the Commonwealth. I'd ask that the court consider the case on the merits at this point. Thank you, Your Honors. It was a privilege arguing before you today. I appreciate it.
Thank you. Okay, Attorney Bowser.
Good morning. Michael Bowser, Chief Justice Budden, all the members, good morning. If it'll please the court, it's Michael S. Bowser, Jr., firmest to Gannett. Seated to my right is my associate, Attorney Samuel Dahlmeyer. I'd like to start with just maybe a version of OUI defense and the way that the world would work if this court were to adopt the position that the government has suggested. Mr. Gannett would be arrested for an OUI offense with an allegation of 2 priors. He is brought to the police station, he is booked, he refuses chemical testing as he is allowed to do so. He suffers a 5-year loss of license. The legislature put into place that protection to protect the public from those that are charged and charged and charged again, and those suspensions are graduated. They go from 180 days to 3 years to 5 years to lifetime. That's exactly what happened here. He's suspended for 5 years. He happens to be spitting up some blood. He's already refused medical treatment, but he's spitting up a little bit of blood. The Sergeant Shamshack of the Essex PD calls fire, EMS to come down. They put him on a gurney. They bring him to the hospital. He has already refused all chemical testing. Now, beyond the sanctity of our homes, I can't imagine something that we would give more privacy interest to than medical records.
Is it the issue whether or not the blood was drawn for medical purposes?
No. His blood, well,
Or did you litigate
Yes.
that?
Well,
Did you litigate that below?
no, that's the Sheldon case. We did not litigate that
Why
issue.
not?
We didn't have to, Your Honor. Honestly, I didn't have to. I
Well,
got the result that I wanted.
I guess you'll find out, but,
I want to.
so you may have gotten the result, you may have
Right.
won the battle and lost the war. So let me ask you a question. What's available to a defendant, correct, as I remember the case law from the district court, or some Superior Court cases, is if someone's in a car accident, they're treated, and as a part of the regular treatment, they run a blood panel to see what's on board of someone, and lo and behold, they run for alcohol and drugs. The Commonwealth then says, aha, we're going to use the blood serum, and they get this conversion. Then there's a motion to suppress, and they bring the ER doc in, and we say, did you do it because the bad police officer was next to you and told you to do it, or did you do that for medical purposes? And that's the litigation that you're familiar with,
That's
right?
the testimony of the Mass General emergency room physician in Dyer. She literally said, I don't listen to what the police say.
Right.
I am making medical decisions.
So in this case,
Yep.
you had the option to litigate that issue, correct?
Whether it was for medical purposes or not. Yes, I did, and I did not.
Okay.
I went based on the development of Bohegan and Moreau.
Right, so you relied on that statutory language, and the fact that you're here arguing this case doesn't mean it's obviously a disputed matter of statutory interpretation. But as far as protecting the defendant's rights not to have the blood drawn and have it used in this manner, there is the issue of whether or not blood is drawn for medical purposes or at the direction of the police.
And if I may, on that point, Your Honor.
Sure.
Okay, so down the road, after a decision is made in favor of the Commonwealth, as mentioned in Moreau, Bohegan, we assume the legislature knows what's going on here at the SJC. We assume that law enforcement is up to speed on what is legal and what is not. And I would also submit, we would expect our citizens to know what is legal and illegal.
But that litigation I spoke of happens all over, in your experience, Lloyd. I'm sure you've brought these motions as well and litigated them.
I have.
Right.
Okay. Your Honor, that panel for medical purposes is critically important to the care of any patient.
Because when I read the facts in this case, I thought, well, why wasn't that motion filed? Why aren't we hearing that?
I had a better argument, and I guess
Okay.
I did not include all my arguments, but I was focused on analysis test of without consent.
Fair enough.
But, Your Honor, that medical panel is designed to give an ER doc information regarding electrolytes, hypoglycemia, kidney failure, lactosis, acidosis, shock, organ failure, liver dysfunction.
Well, that's what makes it reliable. I'm confused by your argument.
I'm saying
What's your point?
it makes it medically necessary. What if Mr. Gannett knows that the sergeant is going to get his records? He's going to say to the doctor in the ER, I don't want a panel. Don't draw my blood.
So you're
And then
asking us to make a public policy decision that the legislature has already made in connection with the statute that's before us?
I don't think the legislature has decided.
Well,
whether-
that depends on how we construe the statute.
There's a statute on medical records, and 23379 is on point. I don't agree with the definition of as to liability. If you're talking about an OUI per se offense, a blood alcohol calculation derived from a medical laboratory test is evidence of liability in a
But
criminal setting.
even if a defendant doesn't want their blood drawn, if someone comes because of the potential for the OUI evidence, as I understand it, or I've heard it before, the ER doc says, this person came in with a head injury. I need to assess him, her, to see what's going on. I'm doing a blood panel because I want to know what's on board this person before we do the MRI, et cetera, correct?
Absolutely. CAT scan, panel, toxicology, they have to know in order to render appropriate medical treatment. We're putting Mr. Gannett in a position, again, if you were to adopt the Commonwealth's argument, he could refuse all that treatment that is necessary to ensure his health. I just think that that's the balancing that's going on
I'm
here.
not sure that, I see that as exactly the balancing. And let me give you a hypothetical that might explain why. Assume everything was the same, except that the medical records were never sent to the police lab for analysis. Instead, what happens is at trial, an expert is called by the district attorney's office, who's not a police officer. There's no direction of a police officer. Okay, so I'm trying to take that piece out of it. And that expert witness looks at the medical records and testifies to the serum blood conversion, or the serum conversion, whatever, does the conversion on the stand. The defendant's, able to cross-examine him as to the validity of that conversion. But on what basis would that conversion be excluded? This statute would not be a basis for excluding that evidence, would it?
So,
Let's take the last question first. I realize I asked multiple questions.
so the last question is this statute, meaning
This
the drunk
statute,
driving statute?
24-1E, would not exclude that evidence.
It would, because it says chemical test or analysis.
By
of-
or at the direction of a police officer, but my hypothetical doesn't posit the direction of a police officer.
So that expert witness comes to trial. He has before him a 3-digit number, which is what's called an enzymatic assay test of serum plasma blood in a hospital laboratory. They separate the solids from the liquid. The alcohol has an affinity for water. It's always recognized to be somewhere between 14 to 20% higher. They take 3 different conversion factors. They apply it to that number, which is beyond the ken of any fact finder or any juror.
So it's an
That's why
expert
the expert
witness.
needs to be there. That's why it's an analysis that no other person could do. And
So it wouldn't be excluded
it should be excluded, because that analysis,
under this statute?
yes,
How? There's no direction of a police officer.
we don't need a blood draw. Well, all right, Your
It
Honor, so you're
only-
talking about analysis at the direction of police officers.
Well, I don't know. It
versus
says,
blood-
provided, however, that if such test or analysis was made by or at the direction of a police officer. My hypothetical doesn't have a police officer involved at all.
Well, someone from the state lab works for the Massachusetts State
I'm
Police,
positing an expert who's called by the DA's office.
outside of the State Police Crime Laboratory.
Yes, how would this statute exclude that testimony?
Because the government is using that blood to prosecute Mr. Gannett in an OUI.
But that's not what the statute says. It doesn't say the government. It says a test or analysis made by or at the direction of a police officer.
Under 24E and under 24F, you can say no. I mean, there's a statutory consent that is built into the OUI statute. 24E says.
You can
at the-
say no to, there's a consent right to expert testimony?
No, Your Honor, there is not. Under your scenario, respectfully, I believe if the defendant has said no, no means no.
But to what?
You can't use my private medical information to prosecute me in an OUI. I didn't consent to the use of my records because my records contain blood. And an expert hired by the government is going to come in, analyze that blood.
So the
convert it.
objection would be to the medical records themselves?
If it contains,
Under which, so that would be an objection under what?
under the statute. He did not consent to the use of his blood sample as collected in a hospital to be used against him in an OUI prosecution.
Counsel, what's your best argument against the proposition that chemical does not modify analysis?
If I may, if you'll just indulge me a couple minutes, I have an explanation I think will shed light that's very relevant on this particular issue. In chemical
That would be
testing,
great.
I'll be quick.
That's, I think that's a better question. So shed some light on the
So
issue of whether
sure.
chemical modifies analysis or not.
The gold standard of blood alcohol testing is gas chromatography with flame ionization. Everyone agrees that that is the very best way to do a whole blood analysis. Below that is a breath test. In a breath test machine here in Massachusetts, it doesn't draw blood. You blow breath into it. It measures and weighs the molecular content of alcohol in the breath sample. Then it applies a conversion factor, 2,100 to 1. And then it prints out a BAC, a blood alcohol content, based on a conversion that the government has built into the machine. There's no difference between the conversion factor that the state lab is using in this case and the conversion factor that they've built in.
Is there a chemical analysis in that?
The infrared light absorption is being measured, both by infrared technology and a fuel cell. There's double.
So it's a chemical analysis. I'm just trying to get your answer to Justice.
It's not a
Bowman's
chemical analysis of blood. There's no blood going into a Draeger alpha test. It is a breath test.
I got you.
And then they're applying
So
a
let's get to
conversion
the
to get it to
blood.
blood.
We're talking about blood here, right? So let's skip to that. So understand the breathalyzer.
Okay,
Keep
so
going.
in a hospital, as I said, they draw blood for medical purposes. They bring it to their laboratory. There it sits. It is tested pursuant to a protocol that hospitals use, which is drastically different than what the state lab uses. And the hospital records from Leahy literally say these tests are for screening purposes only and should only be used for medical purposes. That is, you see that in medical records throughout the Commonwealth from Leahy. Anna Jakes, I know, has the
So
same
those
one.
are actually chemical tests and analysis.
They are, and they're screen, but they're a lower level. I would even put them below a breath test because they're simply screening devices used for medical professionals to make quick, reasonable decisions based what's on board. And the fact that they take that type of result, the hospital tells them, don't use this for legal or employment purposes. They take that sample, apply their conversion rate, and put it into a blood alcohol result.
Doesn't that go to the weight of the evidence as opposed to the admissibility of the evidence under the statute?
I've cross-examined and argued that in courtrooms, but I think the way that this court has set up Pohegian and Moreau, it just begs the question. That is an
Did you
analysis.
answer Justice Wendland's question about chemical,
I'm happy to go back to it.
would you?
Yeah, you were shedding some light as you
Well,
last left it.
through the hierarchy of testing, the point is that this enzymatic profile that's done in the hospital lab is below that of a breath test and only better than urinalysis, which is the bottom of the barrel. So what the government is using, it requires analysis in order to present it to a jury. It's just beyond the understanding of most folks.
But how's
But the
it,
chemical test and analysis that you're describing now that was done for medical purposes with all the caveats of, but don't use this for legal proceedings, that was not done at the direction of the police in this case. At least that's not what you're arguing, right?
Correct.
Right?
Right.
So that chemical test was done by the hospital for medical purposes.
Right.
Why does the mathematical conversion that was actually done by the police, or at the direction of the police by somebody who knows math, why is that a chemical analysis?
Well, Your Honor, there is a chemical analysis going on
Right,
at
but
the
that was
Beverly
done by the
Hospital.
hospital, right? Exactly. We've
Right.
all agreed to that point. There's been a chemical test and analysis. Your position, I thought, was even doing math on that result falls within the statute because chemical must modify analysis within the statute. And I'm wondering why.
Because there's an organic sample in the hospital lab. Chemistry was utilized to get a nanogram per deciliter result, enzyme, and then they're further building upon that by way of analysis. Analysis of nothing is nothing. There was a blood test in a hospital.
Right, but the question is whether chemical modifies analysis or not.
It does.
to me,
In
yeah.
the plain language, obviously, it says chemical analysis, yes.
Oh, so it does. So you're saying math is chemical analysis.
It is if you're analyzing chemicals, and ethanol is a chemical. It's actually a poison, but yes.
Okay.
That conversion factor is an analysis, just like
It's,
just
but
like
it's
it is
a
in the
chemical analysis is what you're saying.
Don't you want to say that it doesn't modify analysis? I mean, I'm just going to give you a chance to think about that, because if it doesn't modify analysis, then you can say, oh, well, there was a mathematical analysis done.
Your Honor, you are correct.
I was just trying to
I'll
help.
take that back, thank you. It is a mathematical conversion, but that is an analysis. And
And can you just take a crack at how reading analysis in this way, which is, a broad reading of the word analysis to comprise any kind of analysis that one might do, including math, how that relates to the purposes of the legislature set forth in this statute here?
the legislature has had every opportunity to modify the statute. They haven't, despite Bohegan and Moreau. And as I said, it's a statutory consent mechanism.
Well, I think that the Commonwealth is arguing that kind of strain of argument actually goes against you, because it's pretty clear from a number of past cases that this mathematical analysis is happening, and the legislature hasn't changed the statute to bar it. So I understood the purposes of the statute to relate in part to bodily autonomy. And how does your argument about whether the Commonwealth can do a mathematical analysis relate to that purpose?
Everything we're talking about began in the body of Denny Gannett. It is his bodily fluids that were gathered at the hospital, not for an OUI prosecution. He's already said no. He already exercised his right to say no. He gave no consent for chemical testing of his breath at the police station. The fact that he finds himself in the hospital should not change that. He still has autonomy in his body.
But he gives consent to the hospital to take his blood. He wants them to find out what's wrong with him, right?
He might not next month.
So it comes down to, if the language is cutting against you, we've got your public policy, which is protecting his privacy even when he's consented to the blood test, versus their view, which is bodily integrity is using the police to force the test, right?
They're not, it is a medical test, but my point is he very well might refuse that medical treatment, necessary medical treatment, if he knows that his no, don't use my fluids, is going to be overridden and backdoored by a warrant, Rule 17.
Okay,
Nothing
thank you.
further. Thank you.